Thank you, Dr. Nayyeri. The chair will now swear you in.
Mr. Witness, thank you for attending the tribunal. Please repeat after me. I solemnly declare that I will speak the truth.
I solemnly declare that I speak the truth.
The whole truth and nothing but the truth.
The whole truth and nothing but the truth.
Thank you. There'll be questions now from counsel, followed by questions from the panel.
Dr. Nayyeri, would you please introduce yourself and also state your professional and educational background?
Yes. My name is Mohammad Nayyeri. I have received my law degree in Iran, where I qualified as an attorney at law and became a member of the Central Bar Association in Tehran in 2005. I have substantial work experience with clients, courts, prosecution officers, as well as the police and other state departments in various parts of Iran. I have also received law degree and a master's degree in the UK, and I hold a PhD in law from King's College London. I am currently based at the University of Kent, where I work as a lecturer in law. I have acted previously as a legal advisor to several NGOs that aim to establish records of human rights violations in Iran. I have conducted research, produced and published reports and legal commentaries on various legal and human rights issues in Iran. My works have been cited, among others, by the United Nations Secretary General and the UN Special Rapporteur on the situation of human rights in Iran. Over the past 10 years, I have also been accepted by courts and tribunals in the UK and various other countries, such as the United States, Canada, Australia, and Norway, as an independent expert able to give opinion on legal issues and conditions in relation to the Iranian legal system.
Thank you. Dr. Nayyeri, you have submitted a report to this tribunal, which appears from pages 334 of your bundle, on the treatment of prisoners and detainees. The tribunal has received and reviewed your report, but would you briefly set out the highlights of that report for the benefit of the tribunal?
Certainly. As I have set out in my report, the Constitution of the Islamic Republic of Iran covers a long list of rights and values, including some of the rights of detainees and principles of fair trial. For example, it guarantees presumption of innocence, prohibition of torture, and the right to access to legal counsel. However, like many other constitutional rights, these have been eroded and significantly restricted under other laws and in practice. The Islamic Penal Code, the Criminal Procedure Code, those are among the major laws that undermine the fundamental rights and constitutional guarantees. In addition, those rights and protections are routinely ignored and violated in practice, particularly in relation to those accused or convicted of offenses that are arbitrarily and too widely labeled by the authorities as security-related. To that must be added major flaws in the structure and administration of the judiciary and criminal justice system of the Islamic Republic. And I refer particularly to the revolutionary courts. And this is also as well as the draconian criminal laws, the cruel and inhumane punishments. So all of these create a toxic mix, the result of which is the ongoing and systematic violations of human rights, in particular of the accused individuals and detainees. Such violations intensify, or perhaps they become better known and get more coverage at times of social and political unrest and periods of more intensified state suppression. In my report, I sought to give an overview of the statutory and practical legal framework of treatment of detainees and prisoners by Iranian authorities. I first explained the prisons management system in Iran, noting the separate regime for security detention centers. As I explained, while abuse and ill treatment of prisoners and detainees is rife throughout prisons and detention centers that are run by the prisons organization, the risk of abuse and mistreatment of prisoners and detainees is even higher in detention centers that are run by security and intelligence forces separately from the regular prison system. I also touched upon serious issues around arrest and detention, where there is a widespread practice of arbitrary arrest and unlawful detention of individuals by law enforcement and security officials. As I have explained, legal safeguards such as the issuance of warrants and summons in conformity with the rights of individuals are routinely violated. Individuals can be arrested without being presented with a warrant or on vague and too widely defined grounds such as national security. I have also commented on the absence of effective procedural safeguards and the prevalent disregard of the judicial authorities for fair trial and due process rights and standards such as the rights of detainees to access to legal counsel, to challenge the lawfulness of their detention, or to remain silent, or not to incriminate themselves, or have the recourse to complain about unlawful detention, or torture, or other ill treatment during arrest or detention. Such rights are routinely violated, and the legal safeguards are ignored. For example, various articles of the Criminal Procedure Code are often invoked to deny detainees legal representation until the pretrial investigations are completed. In addition, because of the overt emphasis that the Iranian legal system puts on confession as a method of proof, detainees and accused individuals are susceptible to forced confessions. My report also comments on the use of torture in interrogations and cruel treatment of detainees and prisoners, whether at the pretrial investigative phase or while they serve their sentences, which almost always takes place away from the public eye. That is unless there is a leak, as we recently witnessed in the CCTV footages from Evin prison. From numerous credible reports and well-documented cases, it is evident that the Islamic Republic fails to bring its prisons and detention centers under effective control and independent judicial oversight. The prisons organization itself is complicit in many atrocities, and when such atrocities are exposed, they engage in denial and cover-up. As far as judicial authorities are concerned, instead of investigating allegations of torture and other violations against detainees, they also tend to become complicit in the systematic repression, not only by authorizing the demands of the interrogators and providing absolute impunity for them, but also by bringing serious charges against those who publicize and protest against those violations. I stop here, and I would be happy to answer any questions.
Dr. Nayyeri, there has been provisions in Iranian law, which although defined under the criminal code, are vague and generally undefined. There are crimes such as waging war or muharebe against God, ifsad fil arz, creating corruption on earth, and recently the publicity against the regime, which are not precisely defined by the legislator or by the, in case of Muharebe and Ifsad, the religious texts are also inconclusive on what the definitions means. What is the impact of that sort of vague crimes, which in all cases carry a very heavy sentence, as it on the judicial process and the rights of the accused?
Okay, thank you. That's absolutely true. Although in the new penal code, they tried to make these types of crimes more precise by explaining them in more precise terms, dividing, for example, Mohammad and Ifsad al-Arz. So each of those are now given separate articles. And the problem now, in addition to vagueness, as much as vagueness, it is also the broad spectrum of activities or actions that fall within those crimes. So they cover a wide range of activities that are completely unrelated, but all of them are considered, any of those, whether financial, some of them are economic, some of them are financial activities, as well as any acts of arson, all of them, for example, fall within the definition of corruption on earth or Ifsad al-Arz. So it is as much as problematic, the vagueness, also the wide range of activities that are covered by those. And the problem, the additional problem on top of all of that is that if there is anything that is not covered or is not included in those articles or is not included in the penal code, for example, there is a gateway open to Islamic Sharia. So anything that is not codified or is not included in the penal code, there is a possibility that the person can be convicted according to the rules of Islamic Sharia. So that gateway is always open.
And when you refer to Islamic Sharia, that is never a clear guide, is it? Because you have majority rule, minority rule, and then, of course, any round the rule or the fatwa by the religious leaders, including the leader of the Islamic Republic. Would that add to the complication and vagueness of these crimes?
That is the inherent vagueness and complexity of Islamic Sharia that will be added to all that vagueness and complexity of codified penal laws. So it is true, and this is what have been creating all sorts of problems throughout the last 4.5 decades, because, as you said, there is no single version of Islamic Sharia, or there is no one interpretation. Although in practice, courts have been trying to follow as much as they could or give priority to the views of the supreme leader of the time. Previously, Ayatollah Khomeini, now Ayatollah Khamenei. So if they have any views on any certain issue, their view would prevail. So courts would regard them as the dominant view under Islamic Sharia. But on other issues, there's a range of views within Islamic jurisprudence, so it is not always clear which view would prevail, which interpretation would the court would decide to follow.
If we move on to another subject, Iran is a member of the International Covenant on Civil and Political Rights, And I assume Iran joined either 1974 or 1975 to this.
Before the revolution, yeah.
Are you aware of any steps being taken for Iran's breaches of this treaty?
Sorry, say that the last sentence again, please. Could you repeat the last sentence?
Are you aware of any steps that have been taken in connection with of Iran's continued breach of this treaty?
There are limited steps that can be taken. Because Iran is a member of that treaty, they have the obligation to report, to regularly report on their compliance with the treaty. So, but the question is, do they? And the answer is no. They don't regularly report on that. The last time they reported was maybe 9 years ago. So, and ever since, there is an outstanding reporting obligation on the side of the Iranian authorities, but they have failed to submit any further reports. And even though last year it was due, there was communication sent by the Human Rights Committee to the Islamic Republic to remind them about their obligation to report on their obligations under ICCPR, but they found a way not to submit the report for all sorts of excuses.
I have two more short questions. My first question is in connection with the shared obligation of the ministers and the leader. I think the Constitution provides under Articles 112 and 137 for joint and several responsibility of ministers and those in charge of the country regarding the breaches they make of Iranian law. Can you please explain what is the position as a matter of Iranian law for this joint and several responsibility?
They form, ministers, they form this body or entity, if you can call them, called cabinet. But it doesn't have that status or joint responsibility. They have certain legal status. They can adopt certain regulations. So, and for that, but each individual is only responsible to the president and also to the parliament for their actions. So it depends on what sorts of responsibility we are talking about. The main type of responsibility they have is to parliament, and they can be questioned by members of parliament, or there can be a vote of no confidence if there is a serious issue in the eye of parliament.
Thank you, Dr. Nayyeri. I don't have any further questions. The panel may have questions for you.
Thank you, Dr. Nayyeri. Just a few questions, please, in relation to the facts that we are considering. And from your report, it's clear that you've reviewed the practices in relation to the protests. Is that correct? The arrest, detention practices?
I have commented generally on the practice of arrest and arrest warrants, etc., not necessarily limited to protests, but protest is one of the contexts that arrest can take place. But it's only one of those contexts.
Thank you. Can you clarify, please, under what framework would arrests taking place within the context of protests fall? Is this a security framework? Is it or a criminal code violation? Could you explain what framework would be applicable and what bodies or authorities would normally have the obligation or the role of arrest?
Thank you. Yes. As we said, one of the contexts that an arrest can take place is in the context of protest, so that is in the street, as opposed to arresting someone in their place of residence or work, or when someone is summoned to the authorities and they decide to keep them. So in the context of protests, the decision to arrest rests with all those who have the authority to arrest, and they are given this authority by law. So according to the Code of Criminal Procedure, all commanders, officers, rank and file police officers who have received the required training, they are allowed and they are given this power to arrest and detain individual in the case of evident crimes. So if they see an offense, they have the authority, legal authority, to make the arrest. But in addition to all of those police officers, there are also besieged paramilitary forces. There are officials of the Ministry of Intelligence. They are included in the list are also IRGC forces. So all of them have equal powers to arrest people. And this is also in the case of evident crimes, which are not always clear and they are not always followed. So even if a crime may not be evident, they may interpret it as evident and then proceed with an arrest. So those are the officials that have the legal power. And in terms of how they can proceed and make the arrest, there are certain provisions in the Criminal Procedure Code that sets out what are their obligations in terms of the rights of the person. For example, it is said, the law says that they have to inform the person about their rights and what happens next in the following hours or days, what are their obligations in terms of surrendering this person to judicial authorities and ask for authorization and permission from judicial authorities.
Thank you. And following on from the arrest, so we can imagine individuals, alleged protesters or whatnot, were subject to an arrest. They were taken somewhere. Within the context of the protests, who would be the authorities who would be running or controlling the places in which the individuals were taken in the context of the protests?
It can be any of those forces. It can be the police, it can be RGC, it can be besieged forces, it can be Ministry of Intelligence, it can be any of those forces. And all of them, as we know, and I have explained in my report, they run their own facilities. Some of them are official detention centers, some of them are safe houses. Nobody knows about them, apart from those running those places. So it is a question of which force, and it's a question of whether they decide to transfer this person to a safe house, to their own facilities, or surrender them to judicial authorities, to official detention centers.
And in practice, is there cooperation between the different authorities in taking those types of decisions?
Sometimes it is cooperation, sometimes it is rivalry and competition. So it is difficult to explain, to describe that sort of relationship as cooperation all the time. So for certain types of crimes or certain types of protests, maybe the RGC wants to have the upper hand and act quicker, arrest more people and have the control. Sometimes it's the other forces. It depends who is the main force dealing with that.
And if I may, moving forward to the next level of the procedure, which would be, one would imagine, the individuals coming before some judicial authority to either confirm the ongoing nature of their arrest or release, though, of course, the panel has heard a variety of evidence on when or if that occurs. But if we, for a second, assume that it would occur, is it a single judicial authority, or does the judicial authority depend on the authorities who were responsible for the arrest?
Okay. Again, it is something that it depends. It depends on the location, for example. It depends whether it is a small town or a big town, or how long that force, either police or IRGC or whatever, they want to interrogate those individuals themselves, or they want to hand over to judicial authorities. Sometimes it's not just handing them over, it is asking permission or being authorized to continue with the interrogation or authorities. So in some cases, the individual is handed over to judicial authorities and the rest are done by judicial authorities. The questioning, the issuing of bail or detention order or any further judicial decision. But in some cases, it is the case that those forces would only inform judicial authorities, and in, I would say, almost all cases, they receive the permission to carry on and conduct the interrogations themselves. So they are being delegated or authorized to carry out the interrogations themselves. So it depends on that.
Thank you. And are you able to comment on the relationship between the judicial authorities and the detaining bodies and the degree of independence that they may hold or not?
In general, it can be, I mean, it's a general description. This is based on the, what I have witnessed over the years. Most judicial authorities are very cooperative, to say the least, sometimes very obedient to the demands of security forces. So it is almost as if that anything they demand, anything those security forces demand, it goes. So it is very unlikely, very unusual for judicial authorities to disagree or disallow something that demand, whether it is renewing the detention order, whether it is rejecting the request by the individual, for example, to have access to the court file, or have access to lawyer or visitation, whatever that request is from the individual, whether the judicial authorities would agree with that, almost always depends on what is the view or opinion of the those security and intelligence forces. If they disagree, the judicial authority very likely would disagree.
Thank you. And if you permit me, just a few more questions. We've heard evidence today and in previous days about individuals coming or reporting to members of the judiciary their experiences of ill treatment, including torture. In those incidents, or there's one I'm thinking of in particular, the judges did not seek to intervene in relation to that situation, quite to the contrary. And in your experience of having reviewed, or your knowledge of this system, is that something which is a typical practice, or have we seen something which is quite unusual in our evidence?
It is typical in the sense that that is the typical approach of judges. However, there may be in some occasions, I have had cases like that I have, or my client have, claim that they have been tortured. So the judge will listen to that, and they may agree to refer the individual to the medical, to the legal medicine organization, the forensic experts, in order to establish whether this individual has been tortured or not, etc. But then they know, or the security forces have already made sure that there are no signs, or they have released the person after the signs of torture have disappeared, or the wounds have healed, etc. Or they know, even if there is such a report, or it is confirmed, it can be easily rebuffed, because they may say the cause of this is unclear. There is no way of proving that this wound was caused during this certain period by this certain officer, for example. So even if they may show that they are following the rules, listening to this, or dealing with this complaint, they know that the end result is that the claim will be dismissed. So it's very safe for them. Even if they agree, they know that the outcome is not going to be that proves this person has been tortured. And sorry to interrupt, and they also, sometimes security forces will also do every attempt, anything in their power to manipulate that process if they can. So I have had cases where the medical report has been taken out of the court file. No one knows where it is, and medical authorities are no longer prepared to produce a second copy. So attempts like this are also very typical.
Thank you. And one more example, if you may. With respect to the process of a trial, which may follow from allegations, and as the evidence we've heard suggests, sometimes from confessions, we've heard that the trials have tended to be rather short. Is there anything you would like to comment on that? Is it something which is which aligns with your knowledge?
Yes, I think that is one of the things as a lawyer or for legal profession in Iran, this has been very problematic, considering that lawyers are often prevented from intervening in the pretrial stage. So by the point that your client or the individual reaches the trial stage, it is the first time you may be able to intervene in the legal proceedings. By that time, when you get the chance to intervene, you will see that your client has already confessed. Under whatever circumstances, they have already confessed to what they are accused of, and probably confessed to something even more than that. So there is very little you can do, because confession under the Iranian legal system is considered as the top of the hierarchy in terms of evidentiary standards and means of proof. So when you have confession, there is nothing to top that. There's nothing there is no additional proof that the court needs. So naturally, the hearing will be very brief, because there is no need for anything else. The court doesn't see any need for anything else. They have what they need. It's a confession. That's all that they need. So very straightforward conviction, unless there is anything you want to challenge and unless the court allows that. Otherwise, it's a serious problem for lawyers to make sure that they can effectively defend their clients, because this means there's very little they can do.
And in your experience, has this resulted in miscarriages of justice?
I think in all of the cases that reaches the that are dealt with by the revolutionary court, sometimes by criminal court, all of those cases that have this nature of security-related or national security, there is an element of that. It's very likely that it happens, and it has happened in all cases I have been involved or been aware of.
Thank you, Dr. Nayyeri.
Justice Yacoub.
Thank you, Dr. Nayyeri. I had no questions to ask initially because I found your report persuasive and very good, and I have no report on it. There are two issues, though. One that has arisen during the evidence, during the questions that were asked of you, and the other, some help which we need, which I'm sure, which I'd like to see whether you can help me with. But I must say that the understanding of the relationship between the provisions of laws and their interpretation, the contributions of the judiciary, the subjective and objective levels of interpretation, in all those matters, I found myself resonating with you. The issue that I need to ask you about has nothing to do with your report, but there is a way out for me from your report. You say that that police may restrict rights concerned with detention and fair trial and so on if they think it is necessary. And I would agree completely that if that is the test, it's a very problematic test, which is highly complicated. But that takes me to another law, and I wondered whether you had any cases, knowledge of any actual cases, instead of just an off the top of your head opinion. There is a law, and I forget the name, or you might even remember it. It's concerned with assembly, and it says that the police may use force or firearms when necessary. Now, I don't know whether that is exactly what it says, because obviously if it says when they think it is necessary, it's a different thing. Are there any cases which deal with that law which we could look at, or which you could tell us about, or which you have personal knowledge of, about the way in which the word necessary is interpreted in that context?
Okay, thank you. Let me find that law. This is I assume, I suppose you're referring to the law of resorting to...
but to deal with people. I hope one of my colleagues find it. I didn't prepare for this question. I thought about it now. But there is a law which says that our firearms can be used only when necessary. But I wonder whether we'd leave it here. I could let the prosecution know which law it is, or they can tell you which law it is. And if you can just provide a note of the cases that deal with this term, it will help me a great deal.
Well, so, I'm aware of the law. It's in front of me. And although in terms of cases...
Yeah. How have your courts have interpreted the law which says you can only use firearms when necessary? Because as far as I'm concerned, necessary is necessary. It's not necessary, you can't use it. And necessary for me is a strict standard. It's not desirable or something. And I wondered whether your courts have given a soft meaning to necessary, like equating it with desirable and words like that, or has it given a strict and hard meaning to necessary?
Okay. In this law, there are a number of references to situations where there is no other way.
Yeah.
Right. So one of them perhaps is Article 4, when say law enforcement forces, in order to control demonstrations and protests or dealing with riots, they can resort to firearms if it is not possible to control those
Yeah.
situations
In any other
without
way, yeah.
resorting to
Yeah.
firearms.
Right.
So I think this is one of the key phrases, provisions in this
No,
law.
no,
that
I
deals-
agree with you on that completely. My only position was, have courts ruled on the thing, do you know? Or can we find out? Because if a court has said something about it, we would like, as a commission, not to ignore that.
I don't know of any courts ruling on this at this moment. I need to check.
Well, if that's not asking you for too much. And just finally, one more throwaway comment. My experience is that the idea of having 5 or 6 or 7 authorities which are responsible for the same thing is that opportunistically they could arrest somebody and blame each other so that you don't know where the person is and where he is arrested. That used to happen in our country very often in those days. It's a very, very convenient tactic. Okay, thank you very much.
Okay.
Good afternoon, Dr. Nayyeri. I also found your testimony very helpful, but I'm still having some opaque bits of the law, if I may clarify. One of the things you mentioned is the idea that there is effectively the Constitution, there's a set of laws, but then there is what you referred to as a gateway to Sharia. Why do you think, and this is just an opinion, so please feel free not to respond, but I just wanted to know whether you thought there was a reason to put in place all that infrastructure of law if you've got Sharia as well, because as I'm sure you're aware, there are countries who have not gone through that process of putting in place a constitution and laws before they resort to Sharia. So what is your thinking of the rationale for putting in place those laws when ultimately you can fall back on the vagueness of the Sharia?
All right, thank you. You need to consider that those laws have come a long journey from the early days of the Islamic Revolution. In the beginning, there were only Sharia laws, and there were courts. Many of those revolutionary courts would act not according to the law, because they believed those laws from the previous regimes were unlawful and they didn't want to follow them anymore. So they started giving those rulings and making decisions based on jurisprudential views and fatwas of the supreme leader at the time. So in their view, Islamic Sharia according to their supreme leader. So from that time to now, there have been developments in terms of codification of new laws that would take into account those Islamic rules. And in certain areas of law, like qisas, or retribution, like diya, or compensation of blood money, etc., or hudud, they have been following them very strictly. It is very much copying and pasting in most cases. But in some cases, recently, that is something we witnessed when the new penal code was adopted, that certain crimes and certain punishments, for example, zanai muhsane, or adultery between married individuals, which was punishable by stoning to death, or certain, punishment like stoning to death, they tried to hide some of those punishments away. So instead of bringing all of them in the code, they just added one little provision saying that anything that is not covered here will be covered by Islamic Sharia. Although at the end they brought several of them back after they had to modify some of them because apparently it caused some problems, some controversy among religious fanatics in the country. But that seemed a clear motivation behind that. they try to hide them away, although they exist, although they are enforceable, but they didn't want to put them in upfront in the law, in the penal code, because at the time the narrative or their view was they trying to show this nice face to the international community at the time. So it was an attempt to just hide the ugly bits or the ugliest bits away from the eyes of everyone.
Thank you. And in one of the examples you gave is the mention of Dia, which has come up several times. I know that your testimony is focused more on detention, but if I may ask you a question about this, because it's not come across in the previous evidence. What is the legal status of Dia under Iranian law?
Sorry?
What is the legal status of blood money or Dia under law? What is the legal status of Dia or
Dia.
blood money in Iran?
But there are certain rules dealing with bodily injuries and death. And death can be either intentional or unintentional. All of them are dealt with under rules of retribution and blood money, or qisas and diya. Anything that is not subject to rules of retribution are dealt under the rules of blood money. So blood money can be paid for someone's death or any bodily injury. And there are fixed rules about blood money that are copied and pasted from Islamic sources to the penal code. And there's a chapter, separate chapter in the penal code that deals with blood money. So blood money is available to anyone who is suffered from any bodily injury, or to the family of the victim if there is a death. And the amounts are fixed, and it is considered as punishment, but it has this dual nature. It is punishment and compensation. So it is not just a monetary compensation, it is only considered as a punishment. So the person who pays blood money is considered to have also been punished. So there is nothing more they need to do, or there is no further sentence they had to go through.
So in the evidence we've heard, when the state has offered Dia, is that an acknowledgement of their responsibility in the death?
There are certain cases that the state takes the responsibility to pay blood money instead of the actual perpetrator. So one of those cases is where the individual is killed, but no one knows, and the state cannot find the killer. So if this happens in a public place, there is this provision under the penal code that it is the responsibility of the state. It says if a dead body is found in a public street, a public road, and the attempts are made, the investigations are made, that they have reached nowhere, and if the killer is not found, then it is the responsibility of the state. So it is one of those examples that the state pays the compensation. There are provisions for armed forces, the police, RGC, etc. That is another example of when they have, in cases when they have followed the rules of resorting to firearms, but an innocent person is killed regardless of their following with the rules. If an innocent person is killed, there are provisions for the state paying the money instead of the officer who shot that individual. So, or maybe it's not clear who shot them, but it's clear that they were shot by the police officers. So the idea is that it wasn't this person is not personally liable. There's no criminal liability in the first place. There's no personal liability in terms of paying the compensation because they killed the wrong person or it was innocent. In these cases, the state pays the compensation. So there are certain situations we can have this liability.
So in
from
this
the state.
last example, am I right to read into that, well, then it's less of the punishment element and more of the compensation element in that balance? Because if the state is saying this was an error, effectively, our officer did everything right and an innocent person got killed, there is no attribution of blame and therefore punishment. There's no punitive element to that. It is a purely compensatory element?
I would think so, because as I said, there is this dual nature to blood money, but in some cases, one of those natures is more dominant. So in this case, in such cases, perhaps the compensation part is the dominant nature of blood money rather than the punitive one.
And in the evidence we've heard, there's often a link drawn, whether intentionally or unintentionally, between the payment of blood money and martyr status for the person killed. Is that something in law, or is that just an understanding of the victims we've spoken to?
I think that's law. Law clearly says that. I don't have that on top of my mind, but it follows from what I described in terms of if there is this situation when the law is followed, but an innocent person has been killed in the exchange of fire, for example, between the officers and officials and the other groups, whatever they are, armed rebels or as the law describes them. If innocent person is killed in the exchange, then there is this possibility to pay them blood money.
And is there an understanding in the law that if you accept the blood money, that is the end of that process, and therefore it's settled as a legal matter?
In most cases, it is. It is still possible if this goes to the court. The court has the discretion in the case that someone has died, in the case of death or murder, if it is intentional and if the court decides, even though the offender pays the blood money and it should be the end of the matter, court has the discretionary power to impose up to 10 years of imprisonment if they see that this caused a breach of public order, for example. So it was a serious crime. They don't want this person to go unpunished. But that's the maximum they can, and it is discretionary, and they don't use it very often, not against their own officials. So it is something that they may occasionally use in very exceptional cases. Apart from those cases, when the blood money is paid, that is supposedly the end of the matter. And the offender walks free.
That's very helpful. My next set of questions is around the relationship of the bodies that you mentioned have the authority to arrest people. Is there any hierarchy between them that we should be aware of? I know they all have equal powers to arrest, but what is the relationship between the police, the IRGC, the Basij, and the Ministry of Intelligence? Can one, for example, demand the handing over of a person because they're more senior, or are they sitting on the same level in the diagrams we've been seeing?
I don't think there are written rules. So there are unwritten rules in terms of who is more powerful. Whether is the police or RGC or others, or Ministry of Intelligence. Police is out of question when RGC is on the ground. So if there is Ministry of Intelligence, probably they are also out of question, because the RGC usually has the upper hand, unless there is a decision by higher ranking authorities from the National Security Council that this incident, let's call the whole issue about the November, for example, let's call this one incident. They may decide that this issue or any other issue or incident is going to be dealt by Ministry of Intelligence. They are in charge. Mm-hmm. Unless there is such a decision, then it is left to them to see there is this power play between them, there is competition between them, And it depends who gets there first or who have the main suspects, or sometimes they both deal with this. Some of them have, and it depends. At the end, maybe some of the high-ranking authorities may intervene. They decide, okay, hand over all of those suspects to the other body. So there's no, I don't think there's any fixed answer or hierarchy to this. It depends on the nature of that situation, whether, for example, it is espionage, something related to nuclear weapons, or it is about armed forces, or protest, public protests, etc. It depends on the topic, it depends on that particular situation, and the power play between those forces.
And am I right that they all, at least nominally, sit under the Ministry of Interior?
Sorry, say it again.
Am I right to understand that they all sit under the Ministry of Interior?
They don't.
Okay.
IRGC is one of the armed forces.
Okay, sorry,
So
that's fine.
it is directly under the supreme leader. So,
Sorry, that was my error.
yeah.
I'm glad you're here.
And Minister of Intelligence is a separate ministry.
Yeah.
So they are also separate, and they are in the hierarchy of political power, they are under the president.
Okay. And then you also suggested that a lot of them have their own facilities. Some might be officials, others might be unofficial places of detention, safe houses, etc. Do you have any indication, or have you seen any studies that reflect the kind of people that end up in the different locations, or the prevalence of one over the other? Or is that too difficult to, or too ambiguous to be able to tell something about?
I don't think there is any comprehensive research or study on that, because it is very difficult. You know, many of those people who have been transferred and kept in safe houses, well, they can tell you they were in a safe house. They cannot tell you where it was. And in many other cases, there's very little evidence, or very little publicly available evidence to do any proper research on that. So it is difficult, although from the accounts and testimonies of victims, you may try to find out some patterns to see certain individuals. It's very likely that they would be transferred to a safe house, for example, first and interrogated, and then. So it is possible, but sometimes it is so arbitrary and so random, it is very difficult to find any principle, any functioning rule here.
And I have two more questions. One is, we've heard a lot about orders being given from at the sort of provincial Security Council level or above that, and that being disseminated down to the forces. Is there anything in the law that specifies that chain of command, like that sort of line manager role? I think that we heard at one point of how such an order would disseminate to the people that are on the front line of a protest.
I need to check the specific laws, but that is the law that all of these security councils, the local security councils, are under the supervision of the National Security Council. I'm not talking about the Supreme National Security, that's a body even higher than that. So all of these local councils are under this National Security Council, which is headed by the Minister of Interior, right? So, and that is how hierarchy works. When we say there is this hierarchy, when there is an order by the person or body at the top of this hierarchy, it comes down and it needs to be implemented by the relevant individuals. If it is addressed to local security councils, if it goes all the way throughout the country, or is it specific province or specific city, depending on those variations. But at the end, when there is order, it comes down through the chain, and all of them, all the relevant people are, that order is addressed to them, they are responsible for implementing that order.
Thank you. And a completely unrelated question. We've seen in some of the evidence reliable reports or death certificates from the forensic medicine department. Are you able to comment about the independence of that department or its reliability? Because it seems to be that it's been very helpful in some of the evidence we've seen. And is there anything for us to draw from that? Are they slightly more independent than I know they are, for example, in the country I come from?
Yes. Because of the type of hierarchy we have under judiciary, because they are not under those deputies or officers or under those the court system, so they are, and there's a reason they are called organizations. So forensic medicine or legal medicine, as they call themselves, organization. So they are given some degree of independence. So they run their own organization, and they are run by doctors, basically. So they're not judicial authorities, they're not judges, prosecutors, etc. So usually they may have reservations. They may have reservation in terms of not telling the whole truth, but sometimes they're very frank. Not always. It depends on that particular individual that writes the reports. They may be more truthful than others, so it depends. There is some, at personal level, there may be some variations. But it is difficult to say they are completely independent. Of course, they're not. And they have all sorts of considerations, reservations, and all reasons why they may not give the whole truth. But in terms of medical expertise, they are reasonably good experts.
Thank you very much.
I've got just a few questions. I won't keep you long. Paragraph 41 of your report, which deals with due process and fair trial rights. You describe there Article 303 of the CPC, the revolutionary courts and their jurisdiction. Now, and you list there the type of offences which are dealt with by the revolutionary court. Enmity against God, corruption on earth, crimes against national and external security. So we shouldn't be surprised then when most of the protest alleged offences were dealt with by the revolutionary court. That's what you would predict according to practice and principle, correct?
Not necessarily. It depends on the situation. If the authorities consider that the police is capable of handling the situation, it may not be, or for any other reason, the motivation why they may not do this or they may decide otherwise is something else, is a separate question. But for whatever reason, they may decide that the police is going to handle this certain situation, not the Ministry of Intelligence or RGC. If there is such a decision, then it will be the police. It won't be others unless there is a need, unless occasionally in certain situations there is a need for other forces to intervene. For example, in certain provinces or certain cities, the police may be overwhelmed or they are not capable of handling the situation, so there may be another force joining them.
Okay. Should we take anything from the fact that, as you've concluded, most individuals prosecuted over their participation in the November 2019 protests were tried in front of a revolutionary court? You've made reference there to some being tried in front of the criminal courts, but most in front of the revolutionary courts. Is that significant? Is that indicative of anything?
Sorry, I think I misunderstood your question in my previous answer. Yes, that's the situation. That is where most, if not all, cases were decided. Although, as I said, there can be this possibility, and there have been cases of double jeopardy when the person is.
But no, my question is, according to you, was a decision then made? If you don't know, you don't know. But was a decision made then that the protest should be dealt with as a general rule under the revolutionary courts rather than the criminal courts?
Oh, that it doesn't work like that, because at the prosecutor's office deals with all cases, and then decide if there is. If this case falls within the jurisdiction of revolutionary court, then they refer it to that court. Otherwise, it can be ordinary criminal court.
So they're looking at the offence that they say has been committed, and in this case they say, well, the protests are in some way against God or in some way against the state, therefore the likelihood is they end up in front of the revolutionary courts.
Yes, that
Right.
decision comes at a later stage in the proceedings.
Okay.
After it is established, or after they are charged with certain crimes and there is an indictment. So if those charges are of these types of crimes, then the case will be heard by the revolutionary court. Okay. If it is just, for example, theft, it was a protester looting, simple looting or theft, then it won't be. It can be, depending on how they interpret it, but according to law, there is a possibility that the case can be heard by criminal court rather than revolutionary court. But in most cases, it would be reasonable to think, and it was the case, that most cases were dealt with by revolutionary court.
Okay. And the revolutionary courts, are there particular institutions which run those courts? We've heard, obviously, about the different groups we're talking about here. Is any one of them more dominant in those courts? Who runs them?
They're part of the judiciary. They're part of the court system under the judiciary. So, and since 2 decades ago, they are also following the same procedural rules as other courts. Previously, they had their own procedures. Now they follow the same rules, although they have this exclusive jurisdiction in dealing with these certain crimes. So they are run by the judiciary. They're part of the judiciary.
Well, let me just qualify my question. Would you expect, for example, to find in the revolutionary court the police as prosecutors, or IRGC, or another group? Is there a predominance of one institution rather than others?
All of those forces, all of those law enforcement forces act as law enforcement forces. So, and when the case reaches the court, depending on which one of those forces have carried out the investigation, they can be influential in terms of producing report, attending court hearing as an expert, because the court may call them to explain. They call themselves expert witnesses. So let me put it this way, that all of them have different levels of influence on the court, but probably IRGC and Ministry of Intelligence have more influence on the court, on the decision of the court. All the interim decisions, preliminary decisions, or the final conviction and sentencing, etc.
Okay, thank you. Now, just a few more questions. You said, you testified that it's rare that the judicial authorities would do something not wanted, let's say, by the security system.
Could you tell me the paragraph number?
You said it in testimony a few minutes ago. You said it's very unusual for judicial authorities to disagree with the edicts, effectively, from the security system.
Yes.
let me just, would you expect the security system, or rather than what you would expect, what do you know? Is the security system more involved with the revolutionary courts than it is with the ordinary criminal courts, or it depends on a case-by-case basis?
No, they are more involved because of the nature of those crimes. Because other crimes are considered as ordinary crimes, they're dealt predominantly by the police. It's only within about these types of crimes that those forces like RGC and Ministry of Intelligence are predominantly involved. It is more likely that they will handle the case. So they are more present and they are more influential in these cases as a result of that.
And you're talking about the Ministry of Intelligence when we're talking about the security service?
Yes.
Right. Yeah. So I just want to understand just a little bit more about the system. Let's say a civilian citizen gets arrested for shoplifting and they go through the criminal court. Is there a difference here between the level of fairness that they can expect as compared to, say, if you go through the revolutionary court on a charge of corruption on earth or armed rebellion against the state? Is one close to due process and one not? Or how do you see it?
Perhaps we can divide two types of cases. In one group of cases, there is individual against the state. In other cases, it's individual against other individuals or other private victims of that crime. So when you make that distinction, then only those crimes that are seen as crimes against the state, and when the offender or suspect is considered as the enemy of the state, it is those types of cases that we are more concerned about in terms of fair trial and violations of the right to fair trial and due process. However, it doesn't mean that in all other cases fair trial rights and due process standards are followed. No, it's not the case, and there are many violations of those rights, especially, yes, shoplifting may be a minor crime. If it is a more serious, even though it's not a crime against the state, but maybe armed robbery against bank robbery or something serious, a serious burglary or very violent crime, they are dealt with by certain departments in the police. They're called agahi. So they use the same thing. They are as brutal and as violent. So torture is also very prevalent there. So it is not only used against those that are deemed as enemy of the state. In ordinary crimes, also depending on the seriousness of the crime, we have the same types of issues.
Okay. So two last questions. One, if during a pretrial hearing an individual is tortured and then confesses, is there an opportunity to challenge the confession at the trial stage? And do any individuals accused ever do so with any success?
I don't know about the statistics or likelihood of success, but some of the cases I have been involved, they have all been unsuccessful. Because, as we discussed, the court either doesn't allow it at all,
doesn't allow the challenge,
doesn't hear anything, they don't want to hear anything about this. Or if there is a torture, there has been torture, the individual it is not likely that the individual will speak up because they are already threatened by their interrogators that if you speak up, we will make sure that you will get a very harsh sentence. So forget about mentioning torture, anything about violation of rights. Just go to the hearing and come back, and you will receive a sentence. If you say anything more than that, we'll make sure you get a very harsh sentence.
And they can do so? They can make that happen?
Yes, that's what we discussed about their influence on the judge, that they have influence on the final outcome as well, about any other decisions, pre-trial or during trial decisions, on bail, on visitation, on right to health care, etc.
Thank you. Last question. Have you any insight into whether anybody arrested during these protests was ever acquitted when going to trial?
I'm not aware of any case, but I have not considered all cases, so
Okay.
forgive me.
Thank you. No, I won't push you. Thank you very much. I think Justice Yaqub's got one question.
Sorry to bother you again, but instead of asking you a series of questions, I'll just put one proposition to you and you can comment and say whether you agree. We might go a lot more quickly. We're talking about blood money. In this case, the unusual thing is that the police people have been offering blood money unasked. Blood money on the condition of getting silence. And my own experience is that states normally don't offer things unasked. And they generally wait for claims and wait for court decisions and so on. And in this case, it's even worse because like in the old South Africa, courts are more likely to decide in favor of the government, and therefore there's no need for the state to pay. And therefore, I'm wondering whether the inference that there is a voluntary offer of blood money in this case, especially since there have been so many, is enough to draw the inference, not necessarily that they plead guilty alone, but that they want to ensure that the thing is kept quiet. That is the real reason. Sorry for such a complex proposition, but if you'd care to comment on that.
Okay. Thank you. I think that it can be the real reason, although it may not be the only reason, but it can be the real reason. And in these cases, it's very likely the reason, because although I have to explain, when blood money is offered, it doesn't mean that the police can pay the blood money. It means the person has to make a complaint, but very quietly, and the court will give the decision. But the person should. They demand is the person should do this very quietly in terms of not accusing anyone, just claiming that our family member or the victim was killed, and we are making no claim about anyone. We are not accusing any individual, among the state officials. So we just are claiming our right under this provision that gives us right to claim blood money in such cases when there is no one, for example, found to be responsible.
What's happened here is a lot more difficult, because here the authorities did not even wait for claims. They offered the blood money without a claim for blood money on the condition of silence. Some refused the blood money on the basis that they refused to be silent and they wanted justice, and others, I think some people did accept it, though I would not like to say so and throw a bad light upon them. But that's why I draw the inference that the motivation behind the payment here, because you don't even wait for a claim as a state, you offer the blood money on the basis that people must keep quiet. That's not a genuine offer of remorse or blood money, is it?
I don't know these situations, so it's a case-by-case decision. It is not, obviously, it is hush money, or how do you describe it? It's just paid to keep the person quiet. The only concern, the only thing I want to comment is that even though it is offered, it needs to go through certain procedures. They need to follow and go to court and give the court order in order for the blood money to be paid at the end. So there are certain proceedings that needs to be followed for that blood money to be paid. But the offer at that stage is the unofficial offer, and if they accept it, it means they can go through that process. Probably it will be very quick proceedings, because the authorities can arrange for this to be done very quickly because they have accepted their offer and they are keeping quiet in the meantime. But I would also think that they wouldn't pay the blood money unless they are sure that the person will keep quiet.
Sorry, so we must now investigate. This is for our counsel, whether in the cases where blood money was paid, there was a procedure or there wasn't. But thank you very much for your help.
No worries. One perhaps very quick comment on that. Sometimes individuals are not fully aware of the legal proceedings behind the scene. They only know that they are being told at the end, sign here, or go, or give us the bank account number, or go and do this and do that. So they're not fully aware of what's going on in the background. They may only know that they are offered this money. So I assume the legal way of doing things, although I wouldn't be surprised if this is not followed in some of these cases, but the legal way of doing these requires following certain procedures.
Thank you very much. I think we've kept you much longer than we should have. Thank you.
No more questions from the panel. Thank you.
I don't have any more questions, but I know we are running very late, but Dr. Nayyeri, in paragraph 36 of his report, which is at your page 345, had referred to a video which is been obtained by hacking the CCTV of Evin prison by a group called Adalat Ali. The video is available, and if you would like to have a look, it's presently being there. It may contain scenes that some find very disturbing. Please show the video. Thank you, Dr. Nayyeri.
Thank you.
Dr. Nayyeri, thank you very much for your report and your evidence, which I'm absolutely sure is very useful for the panel. We appreciate the time you've spent.
Thank you very much. Thank you.